Good evening. This is John Milburn for Laws 12062. This is Alternative Dispute Resolution. We're into week 5 and we're still discussing the issues of the ways in which parties to an ADR session can make the most of their session. During this week, I hope you've been practicing some of your skills. The idea is that you don't read the material in isolation, you read it actively, and you put the material that you read into practice. As an effective ADR practitioner, you are relying on your communication skills, you are actively listening, and you're trying to gauge how others are feeling. So in a social context, do something now during this week, if you haven't already been, to test your skills. Think about questions that you ask of others. Intentionally try asking closed questions, then intentionally ask open questions. See if you get a different response. See if people communicate with you in a different manner. Likewise, with your body language, eye contact, open body language, closed body language, hand gestures, no hand gestures, eye contact. Try just different techniques, even if the other party is aware of what you're doing, and see what type of response you obtain. That will help you in terms of your first assessment in eliciting the best information that you can as an ADR practitioner. What I'm going to do now is share the screen and we'll look at a continuation of the discussion that we had last week in terms of ADR practice. With luck, you can now see slide which is number 6, participation in the ADR process. And it should be the Google photo. You would have seen this last week. Please let me know if that's not what you see. So let's continue on with that process and think about how it works in practice. So in participation in an ADR process, you need to ask a number of questions. We touched on this last week. And I encouraged you to think about building a toolkit. Now, I appreciate that what I'm going through tonight, what I went through last week, is in your Moodle material. But if you've got it, or if you're looking at it now, please turn it to one side because I'd like you to work off instinct or, if you like, memory. So if you're stuck in as the mediator or conciliator and people aren't responding, or you want to encourage people to communicate, what are some of the questions that you might ask of the participants generally? Any thoughts? There's a few stock answers.
That both agree on, something they say get the easy win, something that they'll both definitely agree on.
That's a great way to start. Thank you, B. Try to get some basic agreement between the parties. One other way to do things is to try and have a common cause so that parties stop looking at things from their own perspective and they attempt to work on the problem together. And you may need to ask them some questions to help in that regard. Why hasn't this matter settled so far? What would help to settle this today? What risks do you face if the matter's not settled? And what would you like to get out of today? These are just stock questions that you can ask in pretty much any ADR session. So the idea of the challenge for you as an ADR practitioner is either to remember these sorts of questions or have them somehow written in a form that you can access quickly but naturally and use them appropriately. Develop your own questions. These are just some that I've developed. So there'll be a range of questions that you might want to ask. And the thing about ADR practice is that you don't have much time to think about it. This is not a take-home examination in a sense where you have a couple of hours to think over a thought and then come back with just the right words to express what you want. This is immediate. It's like impromptu acting. And you need to have your toolkit ready to go. So when you're participating in the ADR process, you need to develop some questions, you need to develop some techniques. So what are some of these techniques that we discussed last week? the mediator will use different techniques to increase the prospects of a successful outcome. Now, the first one that you're likely to come across, as we discussed last week, is sponging. It's where you're going to accept some of the emotional outburst, particularly at the outset of the mediation. It's not counselling, it's, as the name implies, absorbing. So practice that skill if you can. Always actively listen and acknowledge. That's an ongoing skill throughout the process. Asking open, exploratory, clarifying questions is always something to be mindful of, but particularly at the start of a mediation or conciliation. Once you've had the opening statements from the parties, and even possibly just before you set the agenda, but more likely after you've set the agenda, you're looking to ask the parties these type of open questions, and you're looking to clarify and explore. Throughout the process, you're looking to summarise what the parties have said, particularly in order to transition. Now, what does that mean? Can anyone tell me what summarise in order to transition actually means, or give me an example?
So you can
yes.
Move on from something, so wrap it up and move forward.
Okay.
Or identify from that issue or statement one thing that still needs to be resolved, rather than just leaving it and moving on. Excellent.
Yeah, thank you, Monique. So one advantage of summarising is that people feel that they've been heard and understood. So that's important. And you've created a feeling, a dynamic that progress has been made. You've summarised the event so far. We've now got that locked in, as it were, and we move on. We transition to something else. So thank you for that. Other techniques that you might consider, obviously the use of silence. That would tend to occur later in the mediation session, at the stage where you're very keen for the parties to take ownership in a very real and practical way of the dispute. If they're not coming forward in a way that you're happy with, remain silent. People like to fill the void, and that may prompt some further discussions. You may have to ask questions for reality testing. Where in the mediation or conciliation process do you think it's most likely that you would be asking questions for the purpose of reality testing? Oops, sorry. I'll just go back.
When people have put up some options, then you're going to check whether these options are actually going to work practically.
That's right. And I think you'd normally ask that sort of question in the context of a private session, is more likely where you'd be asking those sorts of questions. So you can understand the dynamic. People have had their opening statements, you've created and you're working to an agenda of issues, you've had the first joint session, and you've now said, it's a good time to have a break. I'll start with the applicant. We'll talk privately, the discussions will be confidential, and invite the other side, the respondent, if you like, to wait outside. Indicate that as best you can, you'll reciprocate the process with the respondent for roughly the same amount of time. The first question that you might ask the parties in the private session is how they're feeling about the process. How are they coping? Is the mediation conciliation working out as they'd hoped or expected? People will often open up to you. The dynamic will be one of a calming effect. The parties no longer have the protagonist in front of them. They've got you as their new best friend to talk to. They'll relax, they'll confide in you, and to some degree, they'll be asking you to guide them. Now, here's where there's a major difference between mediation and conciliation. In a conciliation, you can ask reality testing questions in both, but if it's a conciliation, you can provide some advice as well. But either way, you're looking to really test the party's, if you like, position, but do so with an attempt to align it with their interests. Are you confident that if the matter does proceed to litigation, you will be awarded an amount that you're claiming? Is there a risk? Can you give me some idea of the cost associated with proceeding, both direct and indirect? How's this going to work for your relationships? These are all questions for reality testing. And what you're doing is you're asking the participant to challenge themselves in terms of what they say and how they think it will work out in the end. Often people, once you've done some reality testing, will understand that they need to move their, if you like, their expectations in order to obtain a favourable outcome. What other techniques do we have? Well, we need to encourage the parties to generate options and possible solutions. Now, I call this brainstorming. When do you think brainstorming, for want of a better term, is likely to occur in a mediation or conciliation process? The start, the middle, the end? Any thoughts? When would you encourage the parties to generate these options and brainstorm? There's no right or wrong answer with these things.
Probably after the issues have been clarified by both parties, John, to see if you can then come up with some possible solutions between the parties themselves.
All right. So when you say clarify the issues, that's, I assume you mean setting the agenda, Nicholas. So you would suggest...
Their agenda's been set. Well, I mean, they're setting the agenda, of course, within reason of what their issues are, and so you're getting them to focus in on their issues rather than their personal stance on the subject.
And of course, you're involved very heavily in that process of setting the agenda items. But yes, now that's good. That's one thought. Are there any other thoughts on when you might use this brainstorming technique? So we've got some private sessions to set the agenda. Any others? Joint session and the opening statements?
What about to break an impasse on a particular area?
That's, in my experience, that's exactly where it's likely to be used. So I would almost certainly, use brainstorming towards the end of the first joint session. That would be where I'd expect to use it, leading into the first of the private sessions, or I may even use brainstorming at the start of the second joint session. So, and that's possibly a good one because people have done some reality, you've done some reality testing privately. You're not going to pass on information. You're not going to let the other side know about your discussions during those private sessions. But you come back in the second session, the mood almost always has changed noticeably. People are more relaxed and they're into problem-solving mode. And that's not a bad time to say, okay, would anyone like to extend an offer? Sometimes people do. They go run with it and you don't need to brainstorm at all. But if you find that at the start of the second joint session, people are reluctant to talk, exchange offers, or to compromise, then you might say, I need your help. And sometimes I do this. I'll say, I need your help. We've all come to the conclusion that it would be best to resolve the matters today. Nothing that we've discussed so far seems to be working. Let's consider any option, all options and any option that might work, and let's see if we can come up with a possible solution. So that's maybe a good time to use it as well. But again, there's no right or wrong answer. What other technique is missing? There's one very important one, the last one, the one that we're now going to talk about for a while this evening, which is not there. What's the other technique?
Reframing, John.
Reframing, yes, the best one. Now, reframing is probably the hardest one, the hardest skill that you'll need to identify. So when we talk about reframing, we talk about detoxification, and we're trying to take the negatives, reprogram them as positive, and encourage the parties to work towards a positive outcome. So reframing is responding to a statement. From your perspective, you have a particular purpose in mind, and you're capturing the essence of what has been said. You're communicating it back to the party that said it in a detoxified form. Now, that's all very well to read about that, but when it comes to your assessment, when it comes to practice, you're not going to be asked what is reframing and what does it mean. What we want to know is, how do you use it? Can you use it on the run? And this is where those of you that have got some acting training and that are quick on your feet will shine. I hope you understand what I mean. So, reframing serves a few purposes. One is that it allows detoxification. That's probably the main thing. The purpose is to strip the emotive content from a statement. So let's take this statement. Now, I know there's an answer in the notes, but what do you think? You're in a mediation session. Somebody says he's always leaving things lying around. Quick fire, what's a reframed statement relevant to that toxic statement? Any thoughts? No thoughts? I've got so many buttons here. I'll just get someone to unmute. If you're probably using the chat facility, I'm having trouble just getting to it. No? Okay. No takers?
I'll try.
Yes, thanks, Monique.
Okay, all right. Probably wrong, but a way you could reframe that is, do you have different ideas of standards of housekeeping? Something like that.
Sure. Yes. So that's asking some questions. Okay. No, that's good. Thanks, Monique. And the hard part about this is that, of course, you don't have time to think about it. It's got to, you have the statement, you respond. You have the statement, you respond. So this is where you need to practice the techniques. So thanks, Monique. That's good. Any other thoughts?
Would you call yourself a very neat and tidy person?
Yes. To which they may say, yes, and that's the problem. I'm neat, he's not. So what we're trying to do is strip the emotive content and repeat it back in a more positive manner. How about this response? So you have concerns about his lifestyle and you want him to know how his actions impact on you. Is that correct? Okay, so you're sending it back with the same sort of message, but we're trying to be positive, and it's a way that we can segue, if for want of a better term, into some other discussions. Let's have a look at another purpose of reframing, and that is for the transition to the positive. So often a statement that is emotive is negative in its connotation. We want to reframe it and move it from the negative to the positive. The purpose is to show a possible solution as a result of doing so. Okay, we're ready? Got our thinking caps on? Here's our statement, and what we want to do is reframe this so that there is a transition to the positive. He never tells me what is going on with the company's finances. How could we reframe that into something positive? Some future possible solution.
Would you like to be kept more informed about the performance of the business?
Excellent. Yes, very good. So what we're doing is we're looking to provide a solution. Thank you. And the example in the notes, so you would like to have direct access to the company's financial records. Yes, I would. That would help. Then I know what's going on. So you can see that you're taking the emotive statement of the personal attack on the other side, into something that is stripped of the emotion, and it is positive in its nature, and provides a possible solution. What else?
John,
Yes, Nicholas?
John, another way of thinking of this, just to try and remove any personal pronouns in your response. So you're removing like the words he and she and those sort of pronouns from your response. Because if you do that, then you're taking away the personal issue and focusing in on the issue itself. Excellent
observation, and I agree with that. I think that's probably a good technique to attempt to foster in terms of practicing for this process. So thank you. All right, so let's transition to the positive. The next type of reframing, the next, if you like, purpose of reframing is transition to the future. So often in a mediation or conciliation session, people want to talk about the past. That's useful in the sense of providing information. It provides us with information that will help to set the agenda. But ultimately, I think you'd agree, by focusing on the past, we're not likely to create an agreement that will have effect in the future. So many of the statements that you receive in the context of ADR will need to be reframed so that we're transitioning from the past to the future. The purpose is to encourage a transition so that the response creates an atmosphere for resolving issues. It's a little like the last one. What we're trying to do is create some options or an atmosphere that helps to create an agreement. Okay, we're ready for the next one. We want to reframe this so that we're transitioning to the future. My daughter was such a lovely girl. I do not know why she has become so bitter. Thoughts?
Okay, sorry, me again.
Yes, no, that's fine, Monique.
Something along the lines of, yes, Ainsley's put it in the chat box,
yes,
and it's much better than what the words were that were going to come out of my mouth.
So thank you, Monique. So Ainsley says, so you would like a positive relationship with your daughter. That's excellent. That's great. It's future focused. It's taken out the emotive content. Just coming back to Nicholas's point, what we've done is we've taken out the he or she, but we're still focusing on a person. So there's a bit of a balancing act there. Any other thoughts? And thank you, Monique. Thank you, Ainsley, for that. So you love your daughter and you want a caring and mutually respectful relationship with your daughter. Having said that, I prefer Ainsley's. Thank you, Ainsley. All right. So there's no right or wrong answer with this, but these are the sorts of things that you'll need to practice. What else do we use reframing for? Transition to interests. So we've talked about the reality of the situation where people will be stuck with their position, their principle. My position is this. Yeah, that's your position, but what's in your best interests? May not be the same as what your position is. Do you really want to pursue this debt for $1,000? That's your position, even though it's going to cost you $10,000 in fees to do so? Is that really in your best interests to pursue your position in this matter? So what we want to do is take statements that are not in someone's interests and transition them to the interests. It's not a judgment call. It's really talking about reflecting on the best interest of the person. So we're emphasizing the importance of dealing with interest rather than positions. We're ready for our example. I cannot live this way with all that noise coming from my neighbour's property. I am not sleeping. Thoughts? How about, so you like living where you are and you want to maintain your lifestyle? Yes. So you can see that there's a common theme with this. When you've reframed the material, what you're looking to do, what's likely to happen is you will get a positive response from the person who made the statement. Yes, you understand me and you're looking for a way to find a solution. Thank goodness. Somebody's listening to me, somebody understands me, and somebody wants me to help solve this problem. You communicate all of that by an appropriate reframed statement. Reframing is also important in terms of transition to interests and a shared approach. The purpose is to encourage a shared approach to a problem so that the focus are on interests rather than positions, and try and do that together. Let's look at this example. Whoops, sorry. Heavy-handed with the... He is so stubborn, he will not even think about how we can pay the school fees. Family law dispute. Parenting. How do we reframe that so that we have a shared approach to the problem? What we try to do is say, use the phrase both of you. So both of you, and what will happen then is that both will almost sit forward. Yes, okay, you're talking about both of us now. So what you're doing is you're sharing the approach, you're sharing the problem between them. So it's important for both to consider how we pay the creditors. Yes, somebody understands and we're in this together. So Ainsley says, you both want to pay the school fees. That's it. Good. Thank you. All right. So the next part is to do with making offers. The way that, and again, this is tailored towards people that are acting for participants, but the same rules apply when you are the ADR practitioner. Often there's a dynamic, people don't want to make the first offer, but there's potentially importance in making the first offer because it establishes the range. And here's an important part of the practice of a mediator or conciliator. You want to package offers so that they cater with all aspects of the dispute, and you're negotiating or assisting the parties to negotiate by comparing apples with apples. What you don't want is, for example, one party to be negotiating in percentage terms without taking legal costs into account, and the other party talking dollar terms inclusive of legal fees. You're not comparing the same things. It makes it very difficult for the parties to follow the negotiations, and it makes it difficult for you. So part of your role as an ADR practitioner is to ensure that all issues that require resolution are on the table and packaged in a form that both people accept, so that we now are negotiating around the same parameters. As an ADR practitioner, you want to ensure that the participants are reassured and that it's becoming a process that is helpful. If you're acting for a party in an ADR session, let them know that they may find the process frustrating, but encourage them to be open and flexible. So it's okay to feel under pressure. The ADR process is not meant to be therapeutic, although it may have that effect. It is meant to assist you to come to a resolution of your problem. If that means to some degree you're under pressure, so be it. having said that, as an ADR practitioner, you need to be mindful particularly of power imbalances. Okay, so let's think about, so that's all for the participation in ADR. Let's think about some specific skills. Now, the first one that I want you to consider is a genogram. I don't know if anyone's ever had any dealings with a genogram, but it's the way in which family or other relationships can be demonstrated through the use of symbols or little charts. And you can see there an example of, if you like, a family tree. So use this technique when taking instructions or when you're preparing for a mediation. Incorporate the results into your mediation or conciliation conference statement, and that is if you're a participant. Prepare a list or flowchart to demonstrate a chronology. So let's just break that down a bit. When you're going through the material ready for a mediation or conciliation, you may have a lot of information about different parties, and parties will want to talk in a familiar pattern. I'm just going to stop the share. No, I won't stop the share. So when we're in a court situation, the lawyers take control. The parties have much less involvement, and you'll hear the lawyers talk to the judge in terms of the applicant or the plaintiff or the or Mr. Jones or Mrs. Brown, things of that nature. Now, that's not the way people talk, is it? They're not going to talk to each other in a mediation or ADR session as the applicant. They might go with Mr. Jones and Mrs. Brown, but more likely, if they're known to each other, they'll use their first names or even their nicknames. And you've got to be on top of it. As the ADR practitioner in a mediation or conciliation, you do not want to stop the flow of worthwhile discussions to say, remind me again, who's Bill? The parties will almost be deflated. You can almost hear them groan, turn to you as one and say, he's Uncle Bill. Haven't you read the file? What's the point of having you as the ADR practitioner? You don't even know who we're talking about. So you've got to be on top of it. You've got to know the names. You've got to know the names, the nicknames, just as well as the participants. Let's stop and do a little exercise. I'm going to share the screen in a different manner. I hope that this works. And if you are a Beatles fan, you'll know what this is. Or if you're a bit younger, you might have heard your parents playing the Beatles over and over again. Apologies to all those that have listened to too many Beatles songs. So are you seeing the words to Rocky Raccoon? Can you just give me a nod?
Yeah, we are, John, but it's
okay. Is it clear enough?
Small, maybe on some screen.
It's more? Okay.
Yeah,
all right. So is that a bit better?
Yeah, that's way better.
Okay. I'm just going to ask you to take a moment, read that, and then I'm going to ask for you to prepare a little genogram, a really simple one. A genogram as in little squares, little arrows, and name or names inside the squares. Now, for those that of you might be listening to this on audio, I'll just read it. Now, somewhere in the Black Mountains of Dakota, there lived a young boy named Rocky Raccoon. One day, his woman ran off with another guy. He hit young Rocky in the eye. Rocky didn't like that and said, I'm going to get that boy. So one day he walked into town, booked himself in a room at a local saloon, and Rocky Raccoon checked into his room only to find Gideon's Bible. Rocky had come equipped with a gun to shoot off the legs of his rival. His rival, it seems, had broken his dreams by stealing the girl of his fancy. Her name was McGill. She called herself Lil, but everyone knew her as Nancy. Now, she and her man, who called himself Dan, were in the next room at the hoedown. Rocky burst in and grinning a grin, he said, Danny boy, this is a showdown. But, all right. So, did you see the idea there? If there was a court case involving Rocky Raccoon, he might be called the defendant, and someone might be called the complainant, or vice versa, or the plaintiff, or Mr. Raccoon or whatever it is, but they're not going to know each other. That's not how they won't talk to each other like that in a mediation session. So have you all created a little genogram? And the idea of this genogram is that you have it in front of you, just in a place that you can see, maybe on a piece of paper, just as a quick reminder where you can dart your eyes down to say, okay, I know who you're talking about. Just a little test. So, someone is talking about Lil. Who's Lil?
Lil is his girlfriend, Rocky Raccoon's girlfriend.
Exactly. Okay. Rocky Raccoon's ex-girlfriend, perhaps. Somebody else says, now, Ms. McGill was always an excellent student. Who's that? Who's Ms. McGill?
That's Lil and Nancy, all the same person.
All the same person. So in your genogram, I suspect you'll have something very simple. I would have a little box in the top left-hand corner, RR, which is Rocky, and then I have a line across to another box, and in that I'd have three names, McGill, Lil, and Nancy, and then I have another down to Danny or Danny Boy. Okay, so really simple, but again, you can understand how you're going to frustrate the participants if you stop them and to say, I'm sorry, who's Lil? It just won't work. Okay, now let's do another exercise, but this time a little bit more advanced. And what I'm going to do is share the screen. Hopefully you can see this. And what I'll do is I'll also read it. The idea is that I want you to create a genogram for use during a mediation session. And I'm just making it a bit easier to read. I'll share the screen now. So on the ready, here we go. And I'll read it as well for those that are listening on audio. To test your skills, please read the following information, create a genogram for use during a mediation session. I'm going to ask some questions about this soon. You act for Jim Brown. Everyone calls him JB. He's having difficulties with one of his neighbours, Mary Jones, who happens to be the sister of his ex-wife. His ex-wife is Betty Brown. JB and Betty were together for 25 years. Dealing with Mary Jones is one thing, but dealing with her mother, Doris Trump, is something else. She's very fiery and she's never liked JB. Doris likes to rule everyone's lives. Doris uses her husband Donald as something of a strong man. He threatens people at Doris's request. JB and Betty have 4 children, Tommy, Jamie, Cody and Jill. Tommy lives with his dad. Jamie and Cody live with their mum. Jill has run off with Jack Green. JB has a new partner, Maud Lee, but everybody calls her Sue. Sue has 2 children from a previous relationship, Derek and Michael. Michael plays soccer with Cody. Sue doesn't get on well with Betty, has some real issues with Mary. Tommy clashes with Mary. JB has a supportive brother, Danny Brown, and a supportive sister, Tony White. They provide evidence to assist JB. In particular, Tony has some very damaging information about Donald. Tony is now going out with Lee Martin. Lee teaches Cody at school, and he heard Doris tell another teacher, Ricky Martin, about what Donald plans to do. So just take 5 minutes and prepare a genogram based around that. I'll remain silent while you do that. How are we doing? Do we need a bit more time or are we ready to go? We're good? Okay, we're good. Okay, now I'm going to ask you this. You've prepared a genogram, or at least I hope you have. For the moment, turn it over, don't look at it. And I'm not asking you a question that you need to answer, but I'm going to make a statement and ask if you could follow this in your mind based on the information you now have. Just see if you can comprehend this readily enough. Danny has recently started seeing Mary, but he could not bring himself to tell JB. Sue is very upset at this latest development and she phones Donald to voice their disapproval. Were you able to follow that? Now turn it over, have a look at your genogram, and I'll read it again and see if it makes it easier to follow the commentary. Danny has recently started seeing Mary, but he could not bring himself to tell JB. Sue is very upset at this latest development and she phones Donald to voice their disapproval. I'll now do a second and a third, and that'll be the end of the exercise. You can choose whether to look at the genogram that you've created in order to follow this discussion or just work off your own memory of what you have read. Here's number 2. In the meantime, Jack and Derek, who are kickboxing enthusiasts, decide to act, and they encourage Tommy to confront Betty. Of course, Tommy has reservations. Jill encourages Jack because she has mother/daughter issues. Were you able to follow that? Okay. And this is the third. Through Cody, Ricky knows Michael. Ricky tells Michael what he heard Doris say about Donald. Now, to me, I've always found that having that little flow chart, some idea of the names and their interrelationship, has helped me when I'm dealing in a mediation or conciliation. That's particularly relevant where you have multi-party mediations. So, for example, if you've got 8 people in dispute, then that type of flowchart in a spot that's handy to you, that you can read, or on a screen, as the case may be, could be very useful. Now, any thoughts about that?
Yeah, just a quick question in regards to that, John. In most cases, wouldn't most of these names and the associations between the parties be known prior to starting any mediation session? So this should be created before we go into mediation, right?
Absolutely, yes. So you should have this material, and the expectation is that when you start the mediation session, you're not asking these questions. And the point of the exercise is really to say, you don't want a situation where you're stopping the flow of the discussions to say, I'm sorry, who's Cody again? It just kills the mediation. So you've got to be on top of it, and it emphasises the fact that in a mediation or conciliation session, you really are in their turf as opposed to in a court situation where they're in your turf, if that makes sense. Okay, that's probably all we need to do tonight, but I will just finalise with a few brief things, if I may. To do that, I'll share the screen once again and return to the slides, but we won't be much longer, and I thank you for your patience. So you should now see the slide that we were working off previously. That's an example of the Genie, that's the interconnection of relationships in Love Actually, which is more complex than the one you've just done. I'm sure many of you would have seen that movie, Love Actually. So that gives you an idea of how you can chart these relationships between people. And some specialty mediation conciliation. Number 1 is QCAT hybrid hearings. In a hybrid hearing, the tribunal hears a matter and makes a decision. The tribunal member writes the decision on a piece of paper with some degree of ceremony, folds that piece of paper, puts it in an envelope, seals the envelope, hands it to the hearing support officer, and then embarks on a mediation with the parties. The idea is that the parties have now heard the evidence. They may have some idea as to which way the member is going to resolve the matter. The member who was sitting at the bench hearing the matter now sits with the parties in a mediation mode. This is a pure mediation model. It's not a conciliation. The mediator cannot give any hints or advice, but it's a last-ditch effort to encourage the parties to attempt a resolution themselves. If the parties come to an agreement, they can then ask the member to make an order which is binding on them, and that which the member had decided is destroyed. If, as a result of the mediation after the hearing, the parties cannot resolve the matter, the member returns to the bench, asks for the return of the decision, unseals the envelope and announces the decision, which then becomes binding on the parties. This is particularly relevant in circumstances where there is some urgency and there's some emotive content. For example, in a dog destruction matter, this might be a relevant technique. Youth justice conferences with respect to child criminal matters may be relevant in circumstances where the child who is charged with a criminal offence is invited to attend a session with the victims in conjunction with their lawyers, social workers perhaps, and police. It's without prejudice, but the result of the conference may be made known to the court, who can then formally make an order. Family group meeting and court-ordered conferences with respect to child protection proceedings are again a special type of mediation or conciliation process, and there are special techniques and processes used in environmental law. All right, so thank you very much for your patience as we worked through those sessions tonight. That's all I propose to do for this evening. Next week we'll be advancing on to different areas. I do hope that you've now got some progress in terms of your assessment piece, perhaps doing some trial runs. I think Neil is still looking for another person to volunteer to join his group, or someone that may be willing to double up. All right, any questions, comments before we wrap up for this evening?
Yes, so it's not next week, it's the week after, isn't that right?
Thank you very much. I'm very pleased you said that, yes. So next week is the university vacation week. So the content for week 6 will be in 2 weeks from tonight. So no session next Monday. All right, very good. Well, we'll see you in 2 weeks, and thank you very much for joining me this evening. All the best. Bye then.